Welcome to this episode of the Legal Paige podcast. Today's episode, I am sharing some insight into the words deposit and retainer. Dun, 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 which is a huge debate in the online world and for basically every small business owner who has contracts in place. I also am going to discuss in this episode what type of additional legal lingo and language you need in your fee clause within your contract in order to avoid the issue of refundability of retainers and or deposits. So let's get into it, shall we?
You're listening to the Legal Paige podcast, where we chat about life and business with a legal twist. I'm Paige, attorney and photographer helping online businesses and creatives tackle their business dreams without breaking out in hives. No more legal mumbo jumbo. This podcast features simple, bite-sized advice that'll have you legally legit in no time. Are you ready? Let's get started. As a reminder, before we get into this episode, I am legally obligated to give my disclaimer. So I am an attorney, but I am not your attorney. All legal information I talk about on this episode is intended for the masses and a large variety of different businesses. I am only your attorney when you hire me and we sign an engagement letter for me to work specifically on your legal issues. Please feel free to seek out another attorney in your hometown if you need specific legal advice or contact me for more information. Alrighty, here's the episode, friends.
Hey everyone, thanks so much for tuning in today. So this topic comes up literally constantly within the TLP community, whether that's on Facebook or Instagram or in my emails constantly. So I thought I would just face it head on. The question is, should you use the term deposit or retainer? Should you use the word reservation fee instead? And then as kind of a secondary question to that, is the deposit, retainer, reservation fee really non-refundable if stated as so in your contract? So I want to just first start out with the definition of these terms, okay? And the definition varies, which is not probably what you want to hear at the beginning of this podcast episode. But a deposit is something that is reserved, but it's an amount that you put down to reserve something. Usually it's like to hold a deposit for something that you're renting, but a deposit is often returned when the services or the thing has been completed. This is a term that was first and formerly used in landlord-tenant law, and that's really important to know where the term of art deposit comes from, okay? So a retainer, on the other hand, is a fee that is paid in advance in order to hold services. A retainer is by default usually non-refundable and not returnable. And instead, it gets applied to the total of the fees paid. Now, the word retainer, again, is a term of art that's used in legal services. So lawyers and attorneys, that word is interchangeable as well. You always had retainers in place for a client to book them in order for them to represent the client. They needed to pay a retainer amount, and then that retainer amount would essentially go towards the client's invoice or billing monthly. So it's like a pay in advance sort of situation. Now, some people, instead of the word deposit or retainer, use the word reservation fee. And that's okay, I will say, because you are just reserving something. So all three of these terms is that they're words, but they're legal terms of art. That's really important to understand. The word deposit has legal meanings in case law precedent in each state, mainly based in landlord-tenant law, okay? Same with retainers. It's really hard to find any type of case law with like photography services or a graphic designer or a website designer regarding the words deposit or retainer. The word retainer, with all this case law precedent, is really only dealing with legal services and attorney fees and issues surrounding that specific matter. So If you don't really define these terms in your contract, then you're going to have difficulties. And that's what I'm trying to get at here. You are going to then have essentially default rules in place that a judge would interpret what your word deposit or retainer means in your contract, because these are legal terms of art. And every state has varying case law precedent surrounding these terms, because all kinds of courts in various states and jurisdictions are dealing with these matters themselves. And so a judge, if you haven't defined like what your deposit is, what your retainer is, if you have the word reservation fee instead, what that is and what it's used for, then that's what's going to get you in trouble. A judge is going to look at what the laws state surrounding that term of art. And legally speaking, I've already told you, like, you're going to be then in like a default world of landlord-tenant law with the word deposit, and attorney, like legal fee world with the word retainer. But those terms of art, deposit and retainer, those words are not really applicable to the wedding industry or the online industry or graphic designers, website designers, calligraphers, virtual assistants, online health coaches, influencers for that matter. So that is why these terms are so hotly contested, because there's really no right answer. So I really don't care what word you use. I'm going to give you my best suggestion to set you up correctly within your contracts. And I'm going to tell you what word we use here at the legal page and why. But in the event that a client is canceling, and here it has to be on the client side, that is where the refundability of either the word, a deposit, a retainer, or a reservation fee comes into play, because you are trying to, in your contract and in your fee section, and then cross-reference probably throughout the entirety of your contract, you're ultimately trying to convey to the client what amount you can keep as the service provider for them voluntarily canceling on you, because you have essentially reserved something, right? Whether that's a date on your calendar or the services you're being provided that are being provided by you. And also saying no to other clients or customers during that time period. So let's just take a wedding photographer, for example. This is a pretty simple explanation. You only have 52 weekends in a year, give or take, usually 52 exactly. And with that means you're probably only going to take about one wedding a weekend. I mean, you might take more, but just stick with me here. If someone is requesting a date, say a really sought after date, 10/10/2010, okay? So it would be like 10/10/10 would be the event date. And usually those type of dates that are repetitive or they're just like cool numbers altogether, though like 2/22/22 has been a big date for next year, or 2/2/22. A lot of those dates get inquiries up the wazoo. So the first person to book with you is essentially paying a deposit, a retainer, or a reservation fee for that date in order for you to cross off that date on your calendar and say no to other inquiries. And especially if it's a date that everybody wants, that is a really essential reason why you have that retainer in place to begin with, because in the event that this client cancels on you, you've already said no to a ton of other clients, hopefully at that point. And then they have probably moved on to a different service provider and have booked that other service provider. So you have an opportunity cost there. You've lost money because they're canceling and they're not fulfilling, the contractual date that they had in place with you. For someone like a brand designer, for example, if you had a certain period of time, usually you're working with clients on kind of a period of time basis as a brand designer. Usually it's 2 to 4 weeks, I would say, sometimes even longer. And you can't efficiently work for all these clients all at the same time. So in order for them to start work with you on, say, January 1st, 2022, they need to book and reserve with some type of fee your services for that period of time. If they want to get all their branding and all their graphics done with you for the month of January, they need to reserve that time period to work with you in advance. So it might not just be a day, it might be a period of time. Or if you have a day rate, if you're a copywriter, then they're reserving that entire day of services for you, whereby you have literally deleted everything off of your calendar except working with that client. So that is ultimately why you have these deposit retainers and reservation fees in place, right? And like I said, it doesn't really matter what term you use. I, however, prefer the word retainer, and here is why. In our legal Paige contracts, we call it a retainer, and then we describe what the retainer is for. So we have found that the term retainer is honestly the most widely kind of accepted across state lines, and the word deposit has been an issue in court for many of our clients and many of our TLP customers. And well, I guess potential customers at that point, because if they're getting a TLP contract, they have the word retainer in them. But people have had issues in, I would say, primarily the wedding and event industry with the word deposit, because under kind of default rules with landlord-tenant law, deposits are often non-refundable if the service didn't actually occur or there wasn't actual damage, like a security deposit. We all understand kind of that colloquial term of art. The word retainer is also very well known to attorneys. And so it's a familiar term for judges and lawyers to understand. We all know why people pay a retainer to reserve, our services, that we are officially retained with them, that we are going to officially start representing them. And when you use the word retainer, you're reserving that date on your calendar, that time period on your calendar, and your services to, X client. When you have the word retainer in your contract, I think that as long as you do all these things that I'm going to talk about here in a second about additional legal language that you need to have in regards to that word retainer, if something were to ever happen and you had to go to court, it's way easier, I think, to explain to a judge or to the opposing party what this retainer word was used for in your contract, because it's just a more common term of art for them. So just honestly, layperson standards for the words deposit and retainer, that is why we use the word retainer. Deposits are oftentimes refundable if you have errors in the language in your contract. So I just suggest not using the word deposit. If you do want to use the word deposit, you just need to be very careful with the additional wording that comes after that, and then be very clear throughout your contract kind of what that deposit is. I like the word retainer. I think that's really helpful. You're retaining services. This amount that the person is paying will also be applied to the total fee. That's what retainers are for as well. So I think that term honestly identifies more with the online service world and one-on-one service world than the word deposit. So I'm going to get off my soapbox there. That's why I love the word retainer rather than deposit. I also think you can use the word initial fee or reservation fee. That works too. And I will say that works just as fine as the word retainer, as long as you are doing the following things. So what's more important than the actual word itself is that this specific payment that you're asking your clients to pay in advance in order to book you or book that date or book your services is these few things. Was it clear to the client why that retainer or deposit was taken at the beginning? Why are they paying this amount? Do you have that explanation in your fee clause? It literally needs to be stated. The client agrees to pay a non-refundable, always use the word non-refundable retainer, which does what? Which reserves the date on the photographer's calendar for the event date listed above. Something along those lines, right? Because probably in, the section of describing like what the event date is and, who the parties are and all of that, you have the actual event date, okay, above in the contract. You also need to explain, is the actual retainer non-refundable? If it is, explain why it's non-refundable. And we're going to get to that with liquidated damages. But essentially, if you have this like really awesome term liquidated damages in your fee clause, that means that it's the opportunity cost, like I talked about, of you not being able to book anyone else on that date and having to say no to other clients. So passing up the opportunity to provide services on this date because your clients have already booked it way far in advance out. And then you also need to explain why that money, that initial amount that they're paying, doesn't go back to them in the event of a cancellation, in the event of a rescheduling situation. Why doesn't it go back to them? Again, you're going to explain because you're saying no to other clients, whereby you won't accept any other clients on that date, whereby you are preparing for services on that date, whereby you're crossing off the calendar date for that your clients requested. All of those things. These are like the whys. You need to have that in your fee section. And then this is a big one that is a gray area, again, legal word, because judges are going to check and see if your retainer was reasonable. That is one of the biggest things to remember. Is your retainer reasonable? So reasonableness is like I said, this gray area term that kind of depends on the facts and circumstances of each scenario. But a judge is generally looking for these few things. Was it clear to the client that the retainer was non-refundable? So like you're stating it, it's conspicuous, it's right in the first paragraph at the very top that it's a non-refundable retainer for X purpose. So again, was it non-refundable? And then number 2 is, why was it non-refundable? Did you literally word for word spell this out in your contract? That's really important. And then a judge is going to decide, is it reasonable? Now, this reasonableness factor is where attorneys kind of come in and they start arguing this was unreasonable, you shouldn't pay a certain amount. I have a whole podcast on why I suggest moving away from a 50% retainer to something that's a little bit less, like 25 to 30%, and then putting in payment plans in order for that reasonableness factor to actually be justifiable. But ultimately what's going to happen is a judge is going to ask you to explain really in black and white, where you honestly came up with this 50%. Is it the cost of your service, or have you actually done all of this work? They're probably going to portion out a certain amount of that 50% for booking the date on your calendar. But if you kind of look at the whole total of your services, so what you do from the initial client inquiry to ending and completing all services for your client, what are the amount of hours you're working for each and every step of that client process? For photographers, there's probably a lot you're doing on the end part of your services, right? So day of providing actual photography services, and then editing and, post-processing and culling and delivery and, getting all that to your clients. That is going to be the bulk of the services you're providing. And so you have to really explain to a judge why you deserve 50% of your total fee when, 50% or more is probably the services that are being rendered really on or around the event date, if not after the event date. So that's why I think a smaller retainer fee is honestly just easier to explain the reasonableness factor. So I suggest about 25 to 30%. And then you can also itemize your services over time, and you can do it on a payment plan. So say for some people like adventure elopement photographers or wedding planners, for example, wedding planners should always, always, always do payment plans in my experience, because Like the non-refundable retainer can be reserving the date on the calendar and like booking and all of the services that you're doing from the get-go, right? You can reasonably justify why you're there having to pay that amount. Say it's like 20%. And then you could have 4 separate payments of additional 20%, which would add up to the full 5, times 20%, 100%. So then you can split all of your services being rendered up to the date of the actual wedding. You're doing so much pre-work as a wedding planner that it would 100% make sense for you to keep the next 20% payment plan that the client is making, and then the next 20% payment that they're making. And so over time, if they do end up canceling like a little bit closer to the wedding date, you can probably keep 60 or 80% of the total fees paid, because you can state not only was the retainer non-refundable, but all fees paid up to the date of cancellation or rescheduling are also non-refundable and are liquidated damages to the company. So there's no one size fits all here. I understand that some people are like dead set on keeping 50% of the cost of like the total service as their retainer fee. I also think that if you are so hung up on like a percentage, that maybe you should look towards a flat fee retainer. And this is what I talk about in kind of the podcast as well. Like, what is an actual flat fee, reasonable amount that makes sense for you to cross off that date on your calendar? Because that is ultimately, at the end of the day, what your non-refundable retainer is for. And so having a flat fee means, okay, this is, all of my booking services, all of the initial inquiries, like inquiry and discovery and phone calls and communication with my clients at the very beginning of the process. And then also having to say no and the opportunity cost of not getting all of these additional, clients on that date or potential clients on that date, because I have to tell them I'm booked. I'm sorry. You're going to have to either choose a different date or choose a different service provider. That is what the retainer is for. So I think a flat fee oftentimes makes more sense, and it is just easier to explain to a judge why you chose that amount. So lastly, I wanted to talk about liquidated damages. This is one of those like magic words and like legal jargon terms that people are like, oh, I don't know what the term liquidated damages means, but I know I need to have it in my contract. And I'm telling you here as TLP, you need to have the term liquidated damages somewhere in your fee clause. So just go look at your fee clause. It should be at the very beginning of your contract. Make sure you have the words non-refundable retainer. Some people also use the words non-refundable and non-transferable. We oftentimes don't put the words transferable in all of our contracts because service providers sometimes do like to offer rescheduling options. And then you are transferring kind of fees paid to a new date. So essentially it's not really non-transferable, which is why we don't put that word in there. But if everything is not transferable and you don't have any caveats with rescheduling purposes, then you can use the word non-transferable. But for all intents and purposes here, let's just stick with it. It's a non-refundable retainer. You're explaining what that retainer is for. You're setting a certain amount, whether that's a flat fee or a percentage. And we just went over that. It needs to be reasonable. You're really explaining why it's non-refundable. Whatever word you use, retainer, deposit, reservation fee, initial fee, that why has to be in that clause. So just make sure you're not blanketly stating the non-refundable retainer is blank and client agrees to pay it, period. If that's it, you're going to have an uphill battle explaining why that amount wouldn't be refundable if your clients requested it. So then usually you're going to have all of that and then, maybe something about late fees in your clause, and you're going to have something about if there's a payment plan, what the other dates of the payments being due are. You're probably going to have something regarding, pricing and your pricing structure and they're guaranteed the price at the time of booking and, maybe there's no downgrades and, if they decide to change anything with the contract or cancel or reschedule, then, the pricing will be in effect at the time of canceling or rescheduling if they choose to do something different or add anything on. So all of that's going to be in your fee clause. And then the term liquidated damages will also be in there. So you have to specify that this particular non-refundable retainer is liquidated damages, because judges don't want it to be a penalty for a contract cancellation. It's not penalizing the client for canceling. It's actually telling the client, like, this is the cost that it is to me for you to terminate the contract and for me to lose out on another client on that date. So, and the word liquidated damages means in legal terms that you are agreeing that the damage amount, you guys aren't going to argue about the damage amount later on, but the damages is X amount. And that is what you guys are agreeing upfront to pay if they cancel, which is your non-refundable retainer. So that's why you have to say, either all fees paid are liquidated damages up to the date, and here's why, or the non-refundable retainer is liquidated damages in the event the client cancels and or reschedules, depending on what your contract actually states. So the one thing I will point out here, though, is it is state-based. So just make sure, you may have some like weird changes to liquidated damage laws in your state. I doubt it, honestly, but I always suggest like you consult with a lawyer in like your local region, in your hometown, to figure out the best way to kind of draft a liquidated damages sentence in your fee clause. But all in all, if you're just stating the word liquidated damages and you're explaining why that non-refundable retainer is liquidated damages in the event that they cancel, and then what is the cost that you guys are kind of agreeing to, which is the amount of that initial fee, and you're able to prove it's reasonable, I really think you're going to be okay in court. I think you've literally armed yourself with every argument possible for you to uphold the non-refundability of that retainer. If you don't have all of these things in your contract, I honestly just suggest you kind of like go back, look at your fee clause, also cross-reference like where else, literally Control F in your Microsoft Word document or Google Doc, and look for the word retainer or deposit or reservation fee, whatever you expressly delineate it as in your contract. Look for that word and see where else it is coming up in your contract, because it's probably in the fee section, of course, at the top. I always say that should be like clause number 1, because people care more about what they're paying you versus like literally anything else in the contract. So always put that top of mind right at the top. But don't please just look at your fee clause. Make sure you're figuring out where else that term is expressed in your contract. Are you still using the words non-refundable? And that there isn't any confusion in your contract, primarily at like a cancellation clause or a rescheduling clause scenario. Would it be confusing to a client whether or not it is refundable or whether or not it is transferable? All of that has to be consistent across the board in your contract. And that's what I have for you today. That is my answer regarding the words deposit, the words retainer. Which one should you use? I think retainer is the best option for you. And are they really non-refundable? In most cases, yes, they are really non-refundable. But I just want to make sure you're not positioning yourself where there is like a partial refund of that retainer because it's unreasonable, or you didn't actually like lay out for the client why it's non-refundable, and then they're going to have questions about it, and so is the judge if you end up going to court. So, you can really set yourself up for success here to ensure that your retainer is indeed non-refundable. If you guys have any additional questions about this, you can always contact me on the TLP Community Facebook page. It's a private group that we have. If you just type in the Legal Page Community on Facebook, the group will pop up. You have to answer a couple questions. We have to make sure you're just a small business owner. And then you can get in there. And if you just need some follow-up here, you have like a nuanced question regarding it, that is where I can answer the questions because it's in a group setting and group forum. I unfortunately can't answer one-on-one questions in DMs just due to legal ethics and responsibilities. But I'd be happy. My team and I monitor that Facebook group. We're in it all the time. And any question that you probably have regarding retainers, deposits, reservation fees, would be really beneficial for other people to learn about too. And so it's going to benefit the whole group if you ask it in there. Thanks so much for tuning in today. I hope it was really insightful for you to learn about this retainer deposit hot heated debate. And I will be back on the TLP podcast, same time, same place next week.
Thanks so much for listening to this episode of the Legal Paige podcast. See, I told you being legally legit isn't so scary. Be sure to visit thelegalpage.com for all show notes. And it would be super awesome if you could head over to iTunes and leave a review. Last but not least, don't forget to join my free Facebook group for unlimited legal and biz Q&A. Chat soon, Legal Pagers.